It's not an argument.
Now, what my rule is under this scheduling order that we put down, that once it's set for trial, then it'll go to trial or he'll plead to the sentence, plead and go to sentence.
Yes, Your Honor.
All right, thank you.
Your Honor, I also have Miss Amber Hayes on the docket.
All right.
Your Honor, Miss Hayes, we're in an interesting situation here. It's taking me a little bit of work, but she has over 2,400 days of credit on this sentence. It's a 8-year at 85%, 8-year 30%. You've served 85% of her sentence at this point, Your Honor. I know we are here on a pending violation. However, with that many credits, it'd be remiss of me to just say plead guilty and other than terminate, because she's hit over 85% of her 8-year sentence, Your Honor.
Have you talked to the state about whether they would agree to that?
I talked to the state, and I don't know that they're in a position to do that because of Mrs. Hayes' record with this court, particularly.
That's correct.
You know, Your Honor.
Carlos not back to court, and then I believe she has new charges.
All right, so you don't have an agreement. So the question is whether or not you want a hearing, or you want to just, if you don't want a hearing, you can plead guilty and go to a sentencing hearing, or you can have a hearing on whether she's violated her community corrections. That's up to you. But as far as me predicting what I'm going to do, I'm not. I don't give advisory opinions.
So, Your Honor, let me have a minute to confer with my client, then we'll come back.
All right, then. Several motions. The first motion is your motion to dismiss counts 1 through 8 based on the statute of limitation.
That's correct. That's the motions, and in looking at the tolling statute in case law, the state is conceding that misdemeanors, Your Honor, they are time barred.
Misdemeanors prosecution must be commenced within 1 year from the date of the.
There's no proof that he was actively avoiding.
So counts 1 through 8 are dismissed by agreement based on being barred by the statute of limitations. All right, and you have also motions.
Well, that would be misdemeanor, not count 1, Your Honor, because that's the felony. Just the misdemeanor count. So that would be count 2.
So the counts 2 through 8 are what you're dismissing.
For Peter, it'll be count 3, 5, and 8. Because the co-defendants are charged together. Mr. Sogg saw every other.
All right, so counts 3,
5.
5, and 8.
Let me make sure that
I'm looking at the indictment, and those do appear to be the ones.
Okay.
And then you also have count 1 and count 10. And those are the 2 that Mr. Clemens is planning to argue about. Mr. Clemens, I will hear your argument. I think your motion is to dismiss count 10, but I think count 1 and count 10 both are covered by your first motion to dismiss count 1 through 8. And then count 10, you've also got a motion to dismiss for failure to state an offense.
Your Honor, I have, of course, the 2 motions. Count 10 is within the statute of limitations, it being a higher class of felony, so it's not an argument as to statute of limitations. It's only
Failure to state an offense.
If I may, I'll launch into my arguments as to count 1 in the statute of limitations.
All right.
Your Honor, in this case, there's a superseding indictment which came out on July the 7th of 2025, and it alleges in count 1 a Class E felony, criminally negligent homicide that supposedly occurred on July the 1st, 2023. Therefore, on its face, this indictment is beyond the statute of limitations. It's been 2 years. It's about 6 days late. The law would allow a superseding indictment to indict the offense after the statute of limitations if the offense had previously been indicted by a prior indictment. This would then only replace that. And so I looked in the file to see whether, in fact, a prior indictment within the statute of limitations had been issued, and found, to my surprise, The answer appears on the record, at least, to be no. Prior indictment was from the May term of the grand jury in 2025. And it has, amongst its charges, there is, under count 2, an indictment for criminal negligent homicide, which matches the language in the superseding indictment. However, when I go to the back of the indictment, I see that there is a list of counts, and next to each is written either true bill or no true bill. And count 2, which would have indicted my client criminal negligent homicide, is not listed on that indictment. This should be apparent from the file. And so for that reason, with nothing to show that my client was ever indicted for criminally negligent homicide under count 2, we cannot show from the record that there was any indictment for this offense prior to the superseding indictment, which, as we noted already, was 6 days late. Now, on that basis, I would ask that the case be dismissed. Now, I will grant that in my informal discussions with the district attorney's office, they say that this was an oversight, a clerical error. Perhaps it was, but if it was an error, I don't know that it was made by a clerk. And even if it was, I think the error is a significant one. Something as significant as forgetting to write that a person was indicted for homicide is significant. It cannot be cured by the later indictment because it is beyond the statute of limitations. I do not know, even if this was some sort of error, whether your honor could or should allow the state to correct that error at this time. If they made a motion to correct a clerical error, I do not know exactly what proof could be presented to your honor as far as what testimony may or may not have been heard by the grand jury as to whether this indictment could have or should have been issued. But as the file stands right now, my client was never, according to this file and according to these indictments that I did provide with, indicted for this criminally negligent homicide until after the expiration of the statute of limitations. On that basis, I would ask your honor to dismiss.
All right. Joan, you want to respond to that, and then we'll move to his next motion.
Your Honor, I did file a response, I believe. I hope that your Honor's had a moment to read that. It is a clerical error, Your Honor. I can be sworn in and testify if I need to, and I have Miss Lynn here. She prepares my indictments, and I approve them. General Kraft approves them. But if you look on the back of the first indictment for May, the issue is there are 2 count 1s. The first one, count 1, 3, 5, 7, 8 are for Socksog. And the next was supposed to be 2, 4, 6, and 9 for Peter. The only issue is there are 2 count 1s. When under Peter's charges, it should have said count 2 instead of count 1. So when we realized we were going to supersede that to do the Miss McDonald as a victim in July, all we did was shift the count 2 that was indicted up count 1. We did not represent this charge. Count 2 was a true bill in May. Count 1 for Sogsog was the no true bill. It is simply a mistake on the back of the indictment. Instead of filing a motion to correct, we just shifted the count up in July. So Mr. Fageltrad was indicted on count 2/count 1 in May, well within the term of statute of limitations. It's a simple clerical error, Your Honor.
You wish to be heard anymore?
Yes, your honor. Your honor, the assistant district attorney has generously offered to be sworn in and to testify for the purpose of being able to say, well, the grand jury actually did vote to indict him for this particular charge. The problem with that I see, it would be that the district attorney is not allowed to be present at the grand jury when they are doing these things by my reading of the law. And it would seem that if we wanted to prove such a thing, we would need to call a witness that was actually there. For example, we could call some of the grand jurors, perhaps ask them, hey, did you guys vote to indict this man for criminally negligent homicide? And if we had perhaps the foreman of the jury say, well, yes, we did. And I say, then I would ask him, Well, why doesn't it say so on the paperwork here? And if he said, well, I forgot to write it down. I forgot to write down count 2. I didn't notice that. We would still then have to decide whether this is the sort of error that can simply be overlooked. But without such proof, I don't think we're in a position to do that. And based on the record, I ask that Your Honor consider dismissing this case.
Well, this court finds somewhat differently in that when the review of the May 2025 indictment, the original one, not the superseding one, the back of the indictment has certain hand notations made. And clearly, the count 1 as to this defendant shows criminally negligent homicide as a true bill. The count 1 also is shown as to Benjamin Sogsog as not a true bill. The error was not in the handwritten portion of that by the grand jury, but rather in the counting of the indictment counts, because there are 2 count 1s, when obviously one applies to Mr. Sogsog, the other to Mr. Whatever, the defendant in this case. It is clear to this court that there is a typographical error made by the defendant, by the district attorney's office in noting the number of the counts themselves. The actual face of the indictment or presentment does show that count 1 applied only to Mr. Sogsog, and that count 2 was to the defendant in this case, and that was a criminally negligent homicide count. So therefore, the court finds that this was an error, a Scrivener's error, or an error in the preparation of the indictment as to the number of counts, but not the offense for which the defendant was indicted, and that has been corrected by the superseding indictment. The purpose of the indictment presentment in any event is to notify the defendant of the crime that he is charged with. And the court is of the opinion that he was given plenty of notice, and that this is not a matter where the grand jury failed to indict him. In fact, it says just the opposite. They indicted him on criminal negligent homicide. It's just the number of the counts that was the error. And that was on the part of the district attorney and not the grand jury. And for that reason, this court is of the opinion that the motion to dismiss based upon that reason would be dismissed, would be denied. We have another motion as to count 10, failure to state a cause of action, if I understand correctly.
Yes, Your Honor. Count 10 of the indictment charges the defendant with reckless aggravated assault. It states that he did unlawfully engage in reckless criminal conduct with a watercraft that resulted in the serious bodily injury of another person. To wit, and here's the portion where they would describe his reckless operation of the watercraft, says the defendant was the adult passenger of a personal watercraft that was being operated by a child under 12 years of age who was operating recklessly and thereby collided with another personal watercraft, causing serious bodily injury to Kayla McDonald. On the face of the indictment, then, you can see that no reckless conduct is alleged against the defendant. It said only that he was a passenger of a watercraft that was being operated recklessly by somebody else. Reckless conduct by somebody else cannot be attributed to the defendant unless the defendant does something reckless himself. It is only alleged that he was a passenger, and Tennessee law does not permit a passenger to be charged with reckless assault based on the operator of a vehicle's reckless conduct as alleged. And when the facts, as in the indictment here, affirmatively negate an essential element of the offense charged, that is, there is no reckless conduct alleged to have occurred by the defendant, it is subject to pretrial dismissal. We ask that Your Honor consider doing so.